Welcome guys to the Carers Leave Act webinar. I'm your host, Robin Hill, and I will be your guide, if you will, through all the nuances and complexities that the Carers Leave Act has to offer. I'm not an expert. I have to say that at the very top. I am merely a host, but I am glad to introduce my expert panel today. I've got Ronan Harvey-Kelly and Polly Whitelam, and I'm very excited to have them here and have their expertise. I'll let them introduce themselves rather than me sort of amble through it. So Ronan, why don't you introduce yourself to everyone?
Brilliant. Thanks, Robin. Hi, everyone. I think first of all, a big thank you for taking the time to obviously attend our webinar. It's hopefully going to be a great discussion. It's amazing to see such a great turnout. It's also amazing to see so many familiar faces. So I would have spoken to a lot of you in a variety of in-person events and virtual events. And so it's great to be speaking again. Obviously, for those of you that I have not met, I'm Ronan. I'm part of the founding team of a company called Lottie. Lottie was born out of the pandemic. It was actually a socially distanced picnic. I can't tell if that kind of feels like yesterday or 10 years ago. It's a very peculiar time, but ultimately the business is on a mission to elevate later living as a whole. And as part of that, I'm building as a part of a wonderful team, a service called Senior Care by Lottie, which is the UK's leading elder care employee wellbeing solution. And so in a nutshell, we help some of the UK's most forward-thinking organisations to understand, find and fund care for their elderly loved ones. So, like I say, really looking forward to this discussion and also hopefully learning a thing or two from Polly as well.
Cool. Thanks, Ronan.
Hi everybody, I'm Polly. I am an employment associate in the employment and reward team at Pinsent Masons here in London. So I advise on all areas of employment law. We advise employer clients in areas such as employee relations, implementation of policies such as those that we're probably going to be discussing today, discrimination, employment tribunal claims, grievances, disciplinaries, the whole host of employment law basically. And I'm going to be bringing some legal expertise to today's conversation.
Great. Thank you so much, guys. Thank you for joining and being our experts today. Just found out that the chat is disabled. So if you do have a question today, please pop it in the Q&A section. We've got Leslie calling in from West Yorkshire. Hope it's sunnier there. But yes, if you do have any questions today that pop up, we've got some time dedicated at the end to answer your questions. So please, any questions at all, no matter how big or small, please just pop them in the Q&A section. That would be great. I just want to say thank you so much for everyone joining us today. We were overwhelmed by the amount of signups we had. We had 200 signups, so thank you all for joining today. That's incredible. For such a seminal moment in care, it's clear that the Carers Leave Act is, clearly on the minds of HR benefits and reward professionals, proactively looking to deepen their understanding. So thank you so much, guys. It's really good. So let's begin. So what is the Carers Leave Act? As early as April 2024, all UK employees will be required to offer their employees up to 1 week's unpaid leave per year to provide or arrange care for a dependent. Now, if you're wondering what dependent means, I'm sure some of you are, this is how they describe dependent: a spouse, civil partner, child or parent of the employee, someone who lives in the same house as the employee, or someone who reasonably relies on the employee to provide or arrange care. So that, in its sort of simplest terms, is the Carers Leave Act itself. It is estimated to directly impact up to 2 million employees currently juggling paid employment and caregiving responsibilities. So it's clearly quite an important act for those people. Given that introduction, what are your initial thoughts, Ronan, on the Act itself? What do you think?
That was a wonderfully succinct overview. Thanks, Robin. I think as a starting point, it's absolutely amazing to see the government prioritise and shine the spotlight on those juggling work and care. It's definitely the most amount of action we've seen in this area for a long time, and it has been a long time coming. And so first of all, it's certainly a positive thing. I definitely agree that in order to make a meaningful difference to millions of employees' lives, I do believe the conversation needs to be driven by institutional policy change, and then for it to trickle down to employers in the UK, such a fundamental part of our society. Like I say, it does feel like a long time coming, and unfortunately we are now playing catch up slightly. We recently ourselves did work with the Daily Express to share that on average unpaid caregivers across the UK are over £3,000 poorer because of their caregiving responsibilities per year, that is, and then spend a minimum of 580 hours caring for their dependent, whether that is, like I say, a parent, a child, someone with a long-term disability, a grandparent, etc. And so if we think about how else this time could be better spent with the right governmental and organisational support, it really paints a picture on why the government are now moving workplace caregiver support to the forefront of their priority list.
Yeah, so I think going off that, you'd say it's pretty significant and pretty timely that the act has come to pass sort of into next year, would you say?
Absolutely. I think it's significant because for one reason or another, caregivers in the workplace have been overlooked slightly for too long. We see from our side, so talking from a Lottie perspective, that employees who have an elderly dependent or obviously a disabled child or a partner with a long-term illness, for example, tend to be extremely reluctant to share this with their employer compared to other instances that might be a little bit more obvious. And so it almost feels like a catch-22 where employees don't know where to kind of turn for advice, support. They almost feel like they have to keep it away from their employer. And by doing that, employees don't know the extent of the issue. And so you might conduct a employee survey and go, oh, only 5% of our workforce have a dependent, when actually another 10% don't feel comfortable sharing that. And so there's massive disparity between, the real impacts of juggling work and care and the awareness, I think, that employers currently have. So I think this policy, this act, obviously will help reduce the stigma. Hopefully it will make employees feel a little bit more seen and comfortable to disclose their unpaid caregiving responsibilities. And that obviously will help HR professionals, reward professionals, employers in general, to make better, improved decisions on policy, benefit, design, etc. And I think, speaking from the perspective of the care sector, specifically, employees usually are having to firefight through tiers. And so as a UK population, we're finding people tend to wait for that emergency situation where they are picked up, dropped into it, where they have no time, no understanding. It feels like the walls are kind of slowly coming in. And so when you're navigating such a complex process, with, again, little to no time and a lack of expertise guiding them, it really does feel like this policy it is significant in helping more employees feel like they can be a little bit more proactive. They can take a few days off to go and look into what is the difference between an adult social care home and an elderly care home, have a look at the local nurseries without feeling like they're letting their employer down. And so I think one of the main reasons that 44% of the UK population regret their care decision is due to this lack of time. And then on the side of that, lack of expert guidance. And so this act will certainly help push forward that conversation and almost help alleviate that stigma that's built up around caregivers in the workplace. Yeah,
I have to agree there. It feels like something I picked up on what you said then was the awareness and pushing the conversation forward. And it feels like a bit of a first step rather than like something that everyone's been talking about. It feels like the first step towards awareness and people feeling seen for the first time. I'm wondering, Polly, how is this different to what we had before in UK legislation? Was there anything before that supported caregivers in the workplace?
Yes, I guess the basic position is there's nothing like this at the moment. The Care Leave Act is going to be it's groundbreaking. It's completely new in its area. It probably would be helpful just to set out what we currently have that supports caregivers. Yeah, so most people on this call probably are already familiar with maternity leave, paternity leave, shared parental leave, which allows maternity or paternity leave to be shared between employee couples. They're obviously all paid entitlements. We also have parental leave, which is an unpaid entitlement and gives employees the right to take 1 week's unpaid leave for each year of their child's life up to the age of 18. But importantly, that has to be kind of pre-planned. It can only be taken in 1 week blocks. It wouldn't really work in the caring context, such as we're discussing today. There's also emergency time off for dependents, which on the face of it sounds like it probably would be quite useful for carers, and is, I imagine, but in very specific circumstances, it can only be used in emergency situations. So say, for example, if my dependent unexpectedly fell ill, or if they were involved in a car accident, I could take reasonable unpaid time off to deal with that emergency situation. But again, it couldn't be used to take, for example, an appointment in 3 weeks' time that I had prior warning of. I couldn't use that entitlement to help in that situation, which the Carers Leave Act will help carers with.
Right.
So I think it's also worth noting actually that at the same time as the Carers Leave Act was passed, government and Parliament also passed an act which is going to give the parents of babies who are in neonatal care up to 12 weeks paid leave, which allows them to support their child while they're in neonatal care, which obviously that's not yet in force either. That will come into force next year, but it kind of showing a bit of a shift from the government. But in terms of what is in force at the moment, I think probably of most use to carers is the right to make a flexible working request. And
Right.
that, for those of you who probably are already aware, it entitles an employee to make a request to either change their contractual working hours, so that would be the specific hours that they work, and the amount of hours that they work, so that would be maybe switching from being full-time to part-time in order to allow them to look after. It's not restricted to carers, obviously, but in a caring context to allow them more time to look after their dependents. And finally, to change their place of work. So if you have caring responsibilities, you could change your place of work from your office to your home. Obviously, an employer is not entitled to accept your request, but it gives carers the ability to make a request to fit their work around their caring responsibilities. So I think that's definitely the most relevant for employees at the moment. However, as again, I'm sure you're aware, it's currently only a right that's available for those who've been employed for 26 weeks by their employer. So it really restricts the number of employees that can take advantage of that. So government actually just a couple of weeks ago have passed a new bill which will make that a day one right. So all employees will be entitled to make that request as of the first day of their employment, which obviously is a great, really, really good movement in the right direction. But I guess that's what we have at the moment.
Yeah.
None of that does what the Carers Leave Act is going to do. The Carers Leave Act allows employees to take ad hoc leave as and when they need to for these caring responsibilities, and kind of blows everything else that they have out the water, really.
Okay, so in that terms, it feels incredibly significant and sort of different from anything that we actually currently have. There is obviously nuances with the emergency leave and things like that, but it does feel really dedicated to that caring sector, doesn't it? That's really good to hear. I'm going to zoom in a bit on the employees themselves and why it's so important to them. Ronan, why do employees need this leave? Why is it so important now compared to before?
Yeah, I think as we all know in this room, COVID has driven a paradigm kind of shift in the employee wellbeing space, with more being expected from employers to support their workforces. I think unpaid caregivers are no different, and so the issues arising from those who are juggling care and work are only set to increase, unfortunately. The ONS, so government data, forecast that by 2024 there'll obviously be more employees with an elderly dependent than a child dependent in the UK. However, I really want to focus on that sandwich generation, because obviously the Carers Leave Act is going to support employees juggling work and then their caring responsibilities across a wide spectrum of dependents. And so as employers, as that proportion of the workforce grows who are sandwich carers, I think it's absolutely vital that obviously policy and then benefits design keeps up with that growth in that percentage of the workforce that ultimately is going to be having to tie down a 9 to 5, 9 to 6, looking after children, looking after parents, grandparents, disabled dependents, etc. And you just kind of look and go, without the right policy and the right support, how on earth is anyone going to cope? And I think that ties in quite nicely with a recent study that the ONS again did, which stated that 27% of the sandwich generation kind of admitted that it causes them abnormal stress levels and even depressive symptoms. And so we really are going to see a crisis where those juggling care and work are going to be, suffering from the mental health side, the financial side. And so it's super important that organizations really get ahead of the curve and start being a little bit more proactive. The general trends have been there, I think, for a long time. We're in an aging population. People are going to be living longer. Naturally, the burden is going to be put more and more on a decreasing healthy working age, a number of employees who are sitting in that healthy working age group. And so as a society, I think we're going to increasingly and drastically need that support from the types of things like the Carers Leave Act, and then obviously more policies that are going to come through the door. And so I think starting by giving employees that flexibility to take unpaid leave is a great thing that will remove the anxiety and the confusion that I think employees are currently dealing with when a dependent requires urgent support, or obviously a long-term care solution. But we all know that these things don't happen overnight. And so is a week enough? It's probably going to be kind of the bare minimum that people require in order to put a care plan together.
Yeah, it's interesting you say that, is it enough? And like you're talking about the mental health aspects and the anxiety that comes with it. What do you think will be the effect on the well-being of unpaid caregivers in general, in the workplace, to themselves? What do you think?
Yeah, I mean, again, this act is definitely just a starting point, but it certainly will contribute to a reduction in the major issues caused by juggling care and work. This is not an exclusive list, but we tend to summarise the issues as absenteeism and declining productivity, then obviously the costs of care, DE&I inequalities, and then obviously the mental health burden. And so the Act will go a long way, I think, in helping mitigate and reduce these impacts. But I think we are right at the start of our journey as a group of UK organisations and obviously experts within the space. And so, for example, we recently conducted some research ourselves, and those specifically that were juggling elder care and work stated that 71% of them admitted their caregiving responsibilities impacted their work within the last month. And so we're seeing, a real frequent disruption in working life and working schedule when those employees do have caregiving responsibilities. And I think often, and at the minute, that comes as a surprise because it's not being relayed and communicated back effectively to HR and reward departments. And so I think the Act will obviously help on the absenteeism side. So I think on average, unpaid caregivers miss around 6 days unnecessarily at the moment. And so employees being able to go, look, I'm not going to try and hide this. I'm not going to try and kind of work whilst I'm on my way to a viewing for an adult social care home. I'm just going to take the day off unpaid, but at least my employer knows the situation and what I'm going through. And I think that's a much better approach for both the employee and then obviously for employers. Yeah. The second part is obviously care costs. From a financial side, I think we all know that we are in slightly unprecedented times in terms of the cost of living crisis. And so those employees that have maybe they have to pay for nursery fees, they might have to subsidise their mum's home care costs. They might have to pay for a disabled child's adult care fees or day fees. And so usually we see a large amount of assets being drained from a family as a whole, or even the employee and obviously the income earner taking on that burden. And so I think the Act, giving people time to actually evaluate their options instead of doing it in a rush, will help slightly reduce the costs that people are paying. But obviously I think more needs to be done from a governmental standpoint and even an employer standpoint to help support those going through and having to pay for the costs of care. I think then on the DE&I kind of side of things, women are 400% more likely to have to reduce their hours or leave the workplace due to taking on the burden of caregiving responsibilities. And so, again, I think the Act will give a little bit more flexibility to female workers, for example, who instead of having to, go, okay, I can't work on Wednesday mornings anymore, I'm actually just going to take a week unpaid leave sort out a bit more of a long-term strategy to make sure that my grandparents' care needs are met. Now, it's certainly, like I say, not the complete solution, but I think it will go some way in helping that D&I side of things as well. And then finally, as I touched upon the mental health side, I think a lot of people don't make that direct link between juggling work and care, and then obviously the mental health burden it places on you. We're talking about people when you step out of the workplace. These are your mums, dads, these are your children, your grandparents, these are your nearest and dearest, and that dynamic, when it changes from caree to carer, is really difficult to cope with from a mental standpoint. And so it's no surprise 84% of employees who juggle care and work admit that they feel more stressed. And yes, time off is one solution, but I also think providing those support services where employees can vent, cry, lean on someone, feel listened to, it is equally as important. So I do think the app's going to go a long way in preventing those issues and ultimately helping employee wellbeing for sure.
Yeah, I mean, yeah, I think you're right. I think it is the start we probably all need. We definitely know it can go further to support financial, DEI, mental health, and all that sort of well-being side. But it does feel like a step in the right direction, at least. Let's play a scenario. I am an employee, obviously, but what if, Polly, I'm an employee and I need to take some carers leave? How should I go about asking my manager? What's the practical way I can go about that?
Okay, so I wish I could give you a straightforward answer to this, but unfortunately I can't.
Good.
It's always a good start, isn't it? And so basically the way that the Act has been enacted is it sets out the basic entitlement, which, as we've discussed, is the one week's unpaid leave that can be taken non-continuously. But it doesn't set out the actual framework that, so to bring it into force, it will require implementing.
What does non-continuously mean?
Okay, so non-continuously means that it doesn't have to be taken in a 1 week chunk.
Okay,
we don't know, other than that, we don't know what it means. All we know that it means is it doesn't have to be taken in one block. So the implementing regulations, which will bring the Act into force, will set out all the specific detail relating to the entitlement. So all we know really is that pretty much what I've just said. All the additional detail will come in the implementing regulations, which means I can't tell you what you have to do in no uncertain terms because we don't know yet.
Right.
But we would expect generally that it will be similar to other types of leave. For example, that you need to give your employer some prior warning, and it probably will be subject to employer approval. But I wouldn't anticipate it to be particularly prescriptive because of the very nature of the leave. Obviously, they're going to be unexpected appointments which come up. So I doubt it's going to say 2 weeks notice must be given. You must get 3 different people's approval. I think it'll be a bit like holiday and unusual leave, to be honest.
Right. Okay. So that makes a lot of sense. That's really good to know that it doesn't come just in one block. You can take it when you sort of need it as leave.
Yeah.
Like annual leave, I suppose. What if, actually, first, do I need proof that I mean, again, you might not know because it's probably not well, thoroughly thought out yet, but do you think I'm going to need proof?
I would be surprised. So there's no mention of that at the moment. But again, like I say, we haven't got the regulations. I would be very surprised for there to be a requirement of proof. And a key term in an employment relationship between an employee and employer is mutual trust and confidence. And therefore, an employer will be required to take it on trust that an employee has caring responsibilities. And if an employer had reason to believe that the employee was being fraudulent and wasn't actually using the leave for those purposes, that would obviously be a disciplinary issue. Right. And could be dealt with on those terms. But in the first instance, I would be very surprised if there's a certain requirement of proof that has to be shown to exercise the right.
Right, good to know. And what if I, as the employee asking for this leave, am refused leave? Well, I mean, it's unlikely, I know, but what if I go, I really need to take some leave in a few weeks, and what if my manager says no? Sorry.
Yeah, never say never. Yeah, so for this, I can give you an answer. The Act itself specifically says that if an employer unreasonably postpones a period of leave or has prevented or attempted to prevent the employee from taking leave, they can bring a claim to an employment tribunal. Okay. That obviously is worst case scenario for both the employee and the employer, because the employee hasn't been able to exercise their right, and presumably they needed the leave for a caring purpose. And it's obviously worst case for the employer as well, because they incur the legal fees of defending the claim, which can be expensive. If the claim is successful, the employee will be awarded compensation, which the employer will be required to pay. And it also, the implications are wider than just the legal and the financial ones. There's obviously going to be negative PR implications for an employer if there's a judgment on this basis against them. And it's also, I think, a key thing is that there's going to be very poor employee relation issues if they're denying to provide this. I mean, they legally have to do it, obviously, but if they're refusing to do it, not only are the legal implications, but there's going to be a lack of employee engagement. There's going to be kickback. I think employers obviously need to comply with it.
I would have thought that culturally, for a workplace, it probably wouldn't go down very well.
No.
If someone is refused, but you never know. Like, it's just one of those sorts of scenarios, I guess, we have to consider. My next question is kind of aimed at you both. On the back of this law, since it is that sort of, it feels like a first step in the right direction. On the back of this law, can employees expect more support from their organisation or even the government sooner rather than later?
I think, I'll kick us off on that point. I think the first part of that is just getting the ball moving forward. I think, like I say, for too long, those juggling care and work have felt a little bit ignored, or they feel not as seen as maybe other employees going through a variety of different things. It's all equally as important, but I think, unfortunately, HR professionals and employers and the government have an impossible task of trying to meet the needs of everyone in the workforce. And I think this act is foundational. It's a starting point, and I certainly think what it will do is drive the narrative. It will drive more awareness, conversations, and ultimately move supporting caregivers in the workplace up the priority list. And that might look, in a practical sense, allocating more budget, setting up a carers community, etc., all the way through to meeting minimum statutory requirements from a policy standpoint. And so there's no question in my mind that this will certainly be the starting point to more comprehensive policies and more organisations looking to actually go above and beyond those minimum statutory requirements.
Sure.
I would agree with Ronan. I think we're very unlikely to see anything further from government. Obviously, caring groups have been pushing for this to be introduced as a paid entitlement for many years, and Parliament have made the decision to introduce it on an unpaid basis. Given the pressure that the Treasury is under at the moment, I think it's highly unlikely that they would subsequently introduce it as a paid entitlement. But I think, completely agree with Ronan, I think we're likely to see it from an employer side of things. I think employers have the option, obviously, to offer it as a paid entitlement or to offer employees longer than just the week that they're statutorily required to give. And I think we're likely to see that. And I also think, exactly as Ronan said, we're likely to see not only employers offering enhanced entitlements, but it's pushing it up the agenda. We're all discussing this today, which if the Act hadn't been brought into force, if the Act hadn't been passed, we wouldn't all be here today talking about this. So it's really pushing it up the agenda of employers. And I think making it a priority and making them consider what other support they can offer to their carer employees. Whether that be benefits such as senior care by Lottie or carers groups like Ronan mentioned. I think really it's so positive, the kind of emphasis that it's placing on carers. Yeah,
I absolutely agree. I think you're right. It's that talking point, isn't it? We want people to be able to talk about this and not sort of feel like still a stigma or taboo. So I feel like it's a really positive step. We focused a lot so far on employees, but if we zoom back out, I kind of want to focus on the employers themselves, because that's a really important part in all of this and in the world and the narrative of this. Ronan, how exactly does this new act, we know it benefits employees, but how does it benefit the employers themselves?
Yeah, absolutely. I think so far I've been probably harsh on employers. Everyone in this room knows that we're all fighting the same battle here to improve employee well-being across the UK. It's an impossible task. Everyone's vying for the same budget. Different employees want different things, and so it is extremely difficult. That being said, I think there needs to be more discussions on where and if there's a limit to the responsibility employers have for their employees' health, finances, care responsibilities. But I do truly believe that caregiving is one that is going to fall on the employer's shoulders. Inevitably, the costs associated with caregiving responsibilities are just extortionate. And so it's not going to be viable for 99% of employees to take on that burden from an emotional, temporal, and then of course, financial standpoint. And so whenever employees find themselves in those situations, I think that's when employers should look to potentially see what support can be provided. Obviously, again, from a policy standpoint, but also going above and beyond that. I think regarding the Act specifically, those employers that are obviously proactive, the government given some guidance. It's not set in stone. It's not confirmed that it might be implemented as early as April 2024. So we now have, say, 6 months where those organisations that are on this call and doing their research separately and are getting engrossed in the conversation and learning a bit more about the needs of caregivers in the workplace and are being proactive, those are going to be the real winners, and I think are going to be in a better position to go above and beyond those statutory minimum requirements, even if that doesn't look like allocating more budget and potentially going and offering a week's paid leave. It might, like I say, look at how can we create a culture that communicates care a bit more openly. How can we connect employees through storytelling who have been through similar things, and just make employees feel like they're less alone? And I think in turn that will obviously help with retention, recruitment, as we see we tend to see people later on in their careers impacted by caregiving responsibilities as standard. Those real talented, experienced members of our workforce are going to be looking at, how does this potential employer, or how does my current employer support me when dealing with my grandparents or my child, etc. And so I think, like I say, the government are starting to prioritise it. I think employers likewise need to prioritise it and open the conversation now, so that if it is April 2024, we're not scrambling to meet those minimum requirements, because undoubtedly there are going to be competitors to businesses that are in this room today that aren't on this call and aren't aware of the Carers Leave Act yet. And so they'll find out about it, a month, 2 months beforehand, and be scrambling. And so if you're there with a plan in place, you've quite clearly gone above and beyond and you've communicated it internally and externally very well, then you're likely going to see those commercial benefits that naturally come along with that.
Yeah, well said. And you talked a bit about retention and recruitment as maybe reasons why. From your perspective, Polly, I don't know what you think, coming from a law employment perspective, but do you think organisations will go one step further than what the statutory obliged to offer?
Yeah, well, it's interesting that Rona mentioned that, because that's definitely a huge thing that we're seeing with our clients. That's a big priority over the last couple of years, definitely post-COVID, is recruiting and retaining the best possible talent. And I think this is an easy way to make an employer stand out from the crowd. Obviously, by a statute, you're only required to offer the 1 week unpaid. If you can offer more, be that in relation to the leave entitlement, or as Ronan mentioned, a more open culture, other support mechanisms, I think that this is the kind of thing that employees are looking for now. The kind of standard benefits are quite standard across the board. And so the more that employers can do to make themselves stand out, the better. And so I think this is a perfect example of things that we are going to be seeing clients introducing to try and stand out from the crowd.
Yeah, I agree. I think it's the finger on the pulse, isn't it? But why should people start prepping now? Or should organisations, should employers start prepping now? HR, benefits teams, whoever, should they start prepping now for April next year, or is there no need? What do you think, Polly?
I mean, absolutely. There's two sides to this. There's nothing to stop an employer introducing it earlier. There's no legal reason why they have to wait until April 24. But if you intend to only implement it in April 24 as legally required, well, whenever it ends up coming in, but we think it will be then, you don't want to be caught on the back foot. You have to be in compliance at that point. And in my experience from dealing with clients, it does take time to roll policies out, to get necessary stakeholder approval. For example, if you decided to enhance the entitlement to your employees, it's not just kind of a 2-week thing that you can turn around and sort that out. So I'd recommend that employers are considering what their position will be at this point. So whether that's the statutory entitlement and enhanced entitlement, start preparing policies, start possibly meeting with and discussing with their employees who have caregiver responsibilities, how they might feel supported, how they think the policy could work in practice. And it just means that you're not caught on the back foot in April 24 or whenever it comes in, which we expect it to be then.
Yeah, you started talking about like thinking about policies for the future, starting that conversation early within your organization. What practical things can HR benefits professionals do, Ronan, do you think, to get ahead of the curve, like now, in approach to April 2024? What are the practical steps that those professionals can do you think?
I think it's really important to always go back to kind of in practice, because policy is a word that's thrown about in this space, and actually nobody kind of at times knows what a policy looks like, or especially in these circumstances where we're kind of in new territory. So I think from a practical sense, I think it's about listening to your workforce. As we all know, there's no point in implementing or going above and beyond when employees, or there's no employees that feel like they benefit from, going above those minimum periods. But I think it's first of all building that culture to enable people to come out the woodwork and go, you know what, I'm not scared that my career is going to be stinted if I share that I've got a parent who's got a long-term care need dependent on me. I'm happy to speak to my HR department, answer a few questions, and ultimately educate. If there isn't someone in the HR team that is going through this, then it's up to, I think there's really useful conversations that can be had internally with employees who have been through it or are going through it, to uncover things that may not have been understood or known. And so I think it's speaking to the workforce, but doing that in the right way. I think that is probably small focus group. So you start with a carers community, so maybe 10 employees. They start feeling comfortable, they speak to colleagues during lunch times, and then it builds naturally and grows naturally. And that's when the company might turn around and go, okay, quite clearly there's a larger percentage of our workforce that has caregiving responsibilities. Let's invest in getting a monthly lunch and learn in place around the topic of care and work. And then, okay, let's have a look at our benefits package. Let's see if it can support the minimum statutory requirements we're currently meeting. And then it might be bigger actions such as, okay, how can we allocate budget here to offer paid leave for carers, which is obviously a big move. But I think it's just about knowing that we can walk before we run. And I think it's a really interesting point that Polly made, is we are seeing lots of organisations implementing policies off the back of the Carers Leave Act being announced, and looking to go live with those before April 2024. And so that by the time it's announced, you can sit there and go, yeah, we've had this policy in place for 6 months. We're now looking at how we can improve it. And I think it's just a much better look. And so again, I'm very aware that it's so difficult now for employers, HR departments, but I think if people can be proactive and we can listen to our workforces, our colleagues, and then take a data-driven approach, that's a great start.
Yeah, I agree. I'm delighted to say, just moving on slightly, that we've had loads of Q&As, loads of questions in the chat. Thank you so much for putting your questions in the chat. I want to highlight each one, because I feel like it's a really important part of the conversation and understanding what the Carers Leave Act is and how it affects you and your organization. So I'm going to turn to a few of these now. And it rolls off nicely, actually, the first one after what you just said, Ronan, because I'm considering like how many businesses have or are looking to make this leave paid. So obviously they have the statutory unpaid leave, but do you anticipate that there are going to be businesses making this paid leave or adding this extra, and how many have already done it? Probably not that many, but what do you think?
I think that's probably one for Polly to start with.
Polly? Yeah, sorry.
Yeah, I can take this one. It's obviously a very new act. It's only passed a couple of months ago, but we are hearing clients talking about it already. It's something that's come up and is being explored. It's very early days, like I said, and I should have clarified this earlier, but obviously because the regulations haven't been passed, even if clients may have to amend their policy slightly once the implementing regulations are published and the kind of finer points are identified. But yeah, it's already something that we're talking to clients about. So it's definitely on clients' radars.
Cool, amazing. There's another question here. When we say 1 week, is that 1 week's worth of their working pattern? I.e., if they work 2 days a week, maybe part-time, that's also a good question. Can they have 2 days of unpaid leave over the year? What does that mean for a part-time employer?
So it's 1 week of your standard working week. So if you work 3 days a week, your entitlement would be to 3 days.
Okay, so like if I'm a part-time employee, then I can still use and benefit from the leave.
Oh yeah, absolutely. It's 1 week calculated on the basis of if you work 40 hours. Well, we don't know. When I say non-continuously, we don't know if you can take it in hourly chunks or in daily chunks, for example. But if you work 5 days, you're entitled to 5 days. If you work 7 days, you're entitled to 7 days.
Okay, really good to know. Thanks, Polly. Louise asks, does this act apply to England, Scotland and Wales, not Northern Ireland?
It applies to Northern Ireland as well. I actually checked this morning. It's England, Wales, Scotland and Northern Ireland. I'm looking now. Section 3.2 says it.
Awesome. Okay, so like everyone feels like all encompassing then across the whole of the UK then. Yeah. Cool, great. Next one is from Anonymous. How do we define a carer for the purposes of this act? If someone is not a full-time carer but works full-time and then cares for all hours outside work, would this act apply to them? Ronan, do you think?
Yeah, I think it's a really interesting topic of discussion and something we've worked hard on when working with our partners on how to communicate internally with their workforces. A lot of people are juggling care and work without acknowledging that they are a carer. They may see it as, I just look after my kids and I go and pick up the shopping for my dad twice a week. That's just out of the love of my own heart as family, etc. I wouldn't define myself as a carer. And so part of this conversation is actually through, I think, storytelling, is making people realize that, you shouldn't feel alone, although it might be just looking after your children, in juggling responsibilities inside and outside of the workplace. Obviously, I'd have to lean on Polly from the legal perspective, but I think it's very common that a lot of people are juggling care and work all hours of the day. This might look like employees calling GPs, emailing, discharge teams from hospitals if mum or dad have had a fall, calling nurseries if their child's off sick, etc. And so it's certainly a grey area, the definition of a carer. I know the Act's tried to define it, but I think this is where HR professionals and employers are going to have to seek expert consultancy to really work out their parameters on how to define a carer. I don't know if you have anything else to add on that, Polly.
Yeah, so in the Act itself, carer isn't defined, so carer isn't defined, but an employee is a carer kind of in the undefined sense if they have a dependent who has a long-term care need. And a long-term care need is an illness or an injury which is likely to require care for more than 3 months, or either a disability for the purposes of the Equality Act, or they require care for a reason connected with their old age. So it's quite broad. As Ronan was saying, kind of how much care you provide to them, whether that's you go and do their shopping for them once every week, or you wash and bathe them and put them to bed in the evening. The level of care required isn't defined within the Act, but broadly, as long as you fit that definition, then you fall within the undefined definition of carer within the Act.
Okay, great, good to know. And I think this one rolls quite nicely off of it because it's a particular scenario. Paul asks, I have an elderly uncle who I'm next of kin to and his main carer for certain needs. He lives alone but is housebound. He refuses care other than from me. Am I entitled to this leave? Paul asks.
Based on that definition, you said he didn't live with him. Yeah, based on that on what you've just described and the definition that I just outlined before, yes, because his uncle reasonably relies on him to provide or arrange care, and it sounds like he either would have an illness or injury likely to last 3 months, or was it his old age? Either way, I'm pretty sure that you would fall within the remit of the Act.
Yeah, so that's an important point to make. It's not within his household, but he readily relies on the care and from no one else. So it does seem to fit, but obviously there are a few nuances in there that hopefully get tidied up before next year, and maybe the organisation can lay out a few more parameters of what they think, and that's the positive mindset at least.
I think just to jump in there on Paul's question, when he mentions he refuses care other than from me, I think that's quite common is families having to persuade dependents that they no longer can live independently. You know, it's not nice someone admitting that they can't live at home by themselves, etc. Specifically on the eldercare side. And so that's quite a common thing that we deal with at Senior Care by Lotte, is actually supporting employees to have those conversations, and actually the family liaison side, which is, you know, how can we enable families, whether it's the employee, the brothers and sisters of the employee, and obviously the elderly loved ones, how can we enable them to get the best care solution without, you know, disrupting their equilibrium and their life and independence where possible. So that's a really interesting and quite a common point, Paul.
Yeah. Thanks, Paul, for your question. Next one is anonymous. Do employees therefore have entitlement to parental leave, emergency leave, and carers leave all within the same year?
Yes, they're all separate entitlements. Are entitled to take each of them. As long as you're using each entitlement for its specific purpose, then yeah, you're entitled to take all of them.
Great. So it's just like an extra addition on the spectrum. Great.
Yeah.
Is the Carers Act live now? I think I can safely say it's as early. It can go live as early as 2024, April 2024. Is that right?
It's received royal assent, but until the implementing regulations are passed, then it's not actually in force. So yeah, we anticipate that to be April 24 earliest.
Okay, great. Another anonymous one is, how do we audit that the leave is used for its purpose, i.e. using it for those we care for, rather than the way to take leave for social reasons? Obviously, this probably comes down to trust, but Polly, would you say they have to audit it, or what would you say the answer is here?
I mean, you should audit the reasons that the employee is given for taking their leave, because if you have reason to believe that they're not using it for its designated purpose, then, like I mentioned earlier, that would be a disciplinary issue. And you obviously want to have a record that they've said it was for whatever purpose it was. And also for your own records, you'll want to be recording the reason for each absence. So yeah, I would definitely, I think in the absence of the implementing regulations, we don't know what the requirements are going to be, but I would have thought it makes sense for requests to exercise this right to be given made in writing, and then therefore the employer, very nature of the applications, has a record of what those recorded reasons are.
Okay, great, good to know. Another anonymous says, I'm implementing unpaid leave of up to 12 months for all carers this year in the company I work. Are there any watch outs about implementing this early?
Shall I take this one? I think the watch out would be the actual regulations haven't been published, so we don't know if there's going to be any tricky nuances. But like I said, we don't anticipate it to be overly prescriptive. So I think roll it out. There's absolutely nothing to stop you doing so. But once the implementing regulations are published, you would need to review those and ensure that your policy is entirely compliant.
Okay, great. And Ronan, what do you think of 12 months of paid leave, on the unpaid leave for carers? What do you?
That's amazing. That's very forward thinking of you, and I think just reiterating Polly's point. You know, I think we can't discourage people if they want to be proactive and get ahead of the curve. That's absolutely what I think more organizations should be doing, but it's just, can we do it with the agility required if there are more details that come out later down the line, which means that you have to slightly update that policy.
Cool. Thanks, Ronan. There's two kind of ones we might have covered, but we'll just make sure we've covered them off. Is that 5 days? Holly asks, is that 5 days for those employees that are part-time employed? And I think we covered that earlier. If you work, for example, 5 days a week, 3 days a week, that counts as your week's leave, doesn't it?
Yeah, it would be whatever your standard working week is, it would be 1 week pursuant to that. So if you work 3 days, your entitlement would be 3 days per year.
Great. And another anonymous one, which I think we've covered off, but just to make sure, is it a week unpaid leave for one period or each year rolling period?
Each year rolling period.
Perfect. Richard asks, do we know yet if this will be an entitlement just for permanent contracted employees or for occasional workers? And again, we sort of touched on the fact that it is for full-time and part-time employees, and that's right.
Yeah, so it's an entitlement for all employees. I won't get into the nuances of whether of employee status. I'm sure some of you on the call know that there's obviously, you can be worker, you can be you can be contractor, you can be an employee. This applies to employees, so it wouldn't apply to workers, which does restrict its ambit somewhat. But I think the test of whether someone is employee is very complicated, and I think we could talk about that for hours. So suffice to say, it applies to all employees, so part-time, full-time, fixed-term employees, all covered, but it wouldn't apply to workers or contractors.
Okay, cool. Helen says, BT here. We incorporated an enhanced version of this leave some time ago. However, what are your views on helping carers navigate the various carers' entitlements as outlined by Polly, i.e. flexible working, family leave, emergency leave, etc.? How do we go about navigating that?
Okay, so I think they're obviously all serve different purposes. I think in terms of how to navigate it, sit down and discuss with the employee which is best to take in each certain circumstance. And emergency leave is obviously very specific for the circumstances. If, say, for example, someone's mother suddenly was in a car accident and they needed to look after them, that would quite obviously be the right type of leave to be exercising in that situation. If, for example, following that incident, they had a lot more caring responsibilities and they needed to be around in the mornings to help them get up from work, get out from bed, then possibly at that point it might be suitable to consider making a flexible working request to change their contractual hours so that they start an hour later or that they work from home. So I think each different entitlement kind of serves a slightly different purpose, and the best way to identify would just be to sit down and have a proper conversation with the employee about it.
Awesome. Okay, brilliant. Anonymous asks, so when we were referring to carer, we are including parents. I'm not sure if she or he means that parents from their perspective, parent to child dependency, or a parent elderly dependency. But is that referring to that within the Act itself?
So it includes, so a person is a dependent of employee if they're their parent or their child. So it works both ways, but it's not just by nature of them being a child or a parent. They would also have to have an illness or injury, disability, or a care need. Yeah.
The next question is, must the carer be the sole carer? Well, unlikely, as they're also the employee, but does the emphasis have to be on like the person providing all the unpaid caregiving responsibilities themselves, or is it just the fact that they can, arrange it for a period?
Yeah, no, so they don't have to be the sole carer. As I explained earlier, the definition is quite loose. So as long as you satisfy the definition of dependent and the dependent has a long-term care need, even if you're not the sole carer, you would, as we understand it currently, there's no case law or anything, which obviously will happen in subsequently. As we understand it, you would fall within the remit of the Act.
Brilliant. Thanks, Polly. Another anonymous, what can we do to ensure this doesn't negatively impact our gender pay gap if we find more women are taking this leave and they're not considering in reporting if they take it in the snapshot month? Yeah,
that is a good question.
There's a few things to pick at there, I admit,
yes.
but it's a good question. It's very in depth, but I mean,
I'm afraid I can't answer that just off the top of it, because I'd have to look more into the gender, like the rules around the pay that's included in the snapshot for gender reporting. I don't know if there would be an exception for something like this. Yeah, sorry, I don't feel like I can give you an answer to that, because I would be shooting from the hip.
No, and I think it's important to say, like, how this is alive and it's like an agile moving act, because it's not coming into force till next year. So I think there's still so much to learn and continue this conversation, because all these things, especially when it comes to DEI, are going to be hugely affected, and people's mental health, absenteeism, productivity. So I think it's really good to ask these questions, but let's continue the conversation. If you want to learn more, contact Pinsent Masons from Polly, or Senior Care by Lottie, Ronan afterwards, and we're more than happy to continue this conversation, see what can be done, and talk about it. Next question, anonymous: can this leave be taken during the notice period after having resigned? That's interesting.
There is
interesting nuance there.
Yeah, really testing me here.
Very good on you, Polly. Yeah, you're doing well. You're doing well.
Thank you. There's no mention within the act of it not applying, my assumption would be that it would apply. However, I would anticipate that if employees are going to be offering enhanced entitlements, we would ordinarily see that you wouldn't be entitled to it within your notice period. That would be the standard position I would anticipate.
Okay, great. Next question. Can an employee apply for the leave if it is an in-law relative? Again, another nuance within the sort of dependency definition, but what do we think on that?
Yeah, as long as they rely on the employee to provide or arrange care and they have a long-term care need as defined, then yeah, they fall within the remit.
Great.
I think just jumping in there, I think a wider point on that is it often is, employees, partners that will be dependent. But as we all know, if your partner is suffering because their parents, their disabled loved ones are becoming more and more dependent on you, it's going to affect the employee, isn't it? And so from our perspective, we often see employees come to us from our partner organizations going, can my partners, can my loved ones access this support on my behalf, because it's their side of the family. And so it's very common to see that question and to see that actually happening in practice.
Yeah, definitely. And last Q&A question for you guys. If a parent is in a care home already, but you want to move them to another one, as you're not the caregiver itself, would you be entitled to that time off, Ronan, Polly?
I think that's probably the legal answer, and then the
sentimental
one. You go first, Ronan, I'll pitch in after.
Okay, so this situation is very, very common. Unfortunately, more needs to be done around ensuring the standard of quality, specifically around care homes. We vet on our side, speaking for Senior Care by Lottie and Lottie, we vet every single care provider we work with, taking in loads of different metrics. And so a really, really comprehensive process to ensure that hopefully less employees who access support aren't going through this situation. It's stressful, it's complex, it's confusing, it's expensive at times. And so this question, I think, applies to a lot of people. And I think people don't tend to necessarily see that side. Again, 44% of people regret their initial care decision. And that's a staggering stat. So more needs to be done to increase the transparency and the quality of advice before that initial care decision is made. And that's exactly why we're here at Lottie. I don't know if Polly wants to add a more legal answer to that.
Yeah, so from a legal perspective, I think you would fall within the definition, again, with the caveat that we've not had any case law on it yet. Yeah. But the definition of a dependent includes someone who reasonably relies on the employee to provide or arrange care. And so in this situation, I think you'd fall within the arrangement within arranging. So I think you'd fall within it there, yes.
Brilliant. Thank you so much. Wow, amazing. Thank you for all your questions, guys. I think we all really appreciate it. We're overwhelmed by the amount of conversation it's creating, and people wanting to find out more and inform themselves, educate themselves, as well as their organisations. So thank you so much. I want to thank Ronan and Polly. Ronan from Senior Care by Lottie, and Polly from Pinsent Masons. Thank you guys so much for lending your expertise. There's one final question. Will you be sending the recording to participants? Yes, we will. Yes, we will. That's a very functional question. I like that because I can answer it. Good. Just before we leave, I kind of want to answer, I've had this in my head throughout, and I kind of want to leave it as a final note. But just after the thank yous and things like that, I just want to pose one more question to you both. The Carers Leave Act, 1 week's unpaid leave, is it enough?
I'll kick us off. It's a big question. First of all, I've really enjoyed the discussion. Thanks for having me on the panel. I think it's sensational news for unpaid caregivers, but it certainly isn't enough. As we all know, care is not linear, meaning you don't just tend to take a week's unpaid leave and then everything's sorted. There's all sorts of nuances, changing circumstances, complexities that require a continuous effort at making sure that dependents are cared for. So it's not enough, but we really appreciate kind of Parliament's initial efforts to action better support for employees with caregiving responsibilities.
Brilliant. And Polly?
I'm conscious of time, so I'll be very quick, but agree with Ronan largely, but I'd say I don't think it's enough by itself, but combined hopefully with proactive action from employers, I think it's definitely a step in the right direction. So yeah, very positive first step.
Brilliant. Thank you again, guys. We're now at midday. Thank you so much for joining. This recording will be sent. Thank you to all the participants and the people attending, and to Ronan and Polly again. Thanks very much. Take care and have a lovely day.